Hi, it's Bobby Welsh at Simple Financial Planning. Today's video is all about estate planning, wills, powers of attorney, and general trusts and gifts. And the guest today is Bill Thompson of Legacy Planning Solutions, who we've known for a long period of time, has an exceptional knowledge of everything to do with estate planning. Really hope that you're going to get something of use from today's video. Thank you. So thank you very much, Bill, for joining us today. Bill's going to have a quick chat with us with regards to estate planning, powers of attorneys, wills, trusts, etc. as well. So how are you today, Bill?
I'm very good, Bobby. I am, very good, very busy, which is great.
You're growing the beard out as well?
I am growing the beard. You can see it's very grey. I might cut it back so that I look younger, but you never know. I think that's a lost cause.
Thank you very much for taking the time to join us. I know that you're really busy as well just now. So really the purpose of the kind of conversation, Bill, is just to bring a little bit of information to some of our clients to let them know, maybe dispel some of the myths regards to estate planning. And obviously you've been in the kind of industry a long period of time, and thank you very much for sharing your expertise with us. So if it's okay, what we'll do is we'll crack on with the questions, and hopefully we can bring some information to the client.
Yeah, fire away.
Okay, so the first question, Bill, is probably in regards to the wills side of things, and the kind of the common thing that we get from clients is that it's quite time consuming. So first of all, why should I get a will?
Well, first of all, I think in terms of the time it's going to take, it usually takes a bit less time than people think, and it's usually a lot less complicated than people think as well. So that I think is what puts people off actually doing a will. Most people know that they really should be doing a will. And you're in the business of helping people buy property and invest their money and what have you. And if you've got property, you really do need a will. By investing a wee bit of time at the moment, what you're going to do is you're going to save those that you leave behind, whether it's family or whether it's friends or whatever it might be. You're going to save them an awful lot of time, and you're going to save them a lot of money as well. If you die without a will, then the one thing that you'd need to bear in mind is you've given up the right to decide where your estate is going to go to. So you're leaving that to the government to actually decide. Then not many folk like the idea of the government dictating where their estate is going to go.
Yep.
Because we all try hard to build up our assets, whether it's by buying a house, whether it's by investments or whatever it might be. And we want to leave that to people that really matter to us.
Just so that people are aware, what actually happens if I die and I don't have a will?
Well, if you die and you don't have a will, then what you've got to do is your next of kin, whoever that might be, the courts will appoint them as an executor. Now, that's quite a process to go through. So that takes a lot of time. The courts will decide who is going to actually implement your estate. And really what happens is you need to create a will. So the courts are going to do that for you. So it imposes on your next of kin whether they're capable or not of doing it, or whether they're able or not really to do it. Then they are going to be appointed as executors to look after the will. But it does mean that your estate is going to be distributed in line with the succession laws, and the succession laws lay down who is going to inherit your estate. And that might not be the person that you actually want to inherit it. So in summary, Bobby, really, if you don't have a will, it's going to take a lot more time to get your estate sorted out. And that's really distressing to the family that you leave behind.
Of course.
And it's going to cost you a lot more money, because you're going to have to, you will have to use a solicitor to get that done. And you've got a lot of extra processes to go through to get the executors appointed that you would have done otherwise had you made the will yourself.
And can you give a kind of rough indication of the timescales that would take without a will, or costs? Roughly?
Well, in terms of the timescales, you're looking at putting months onto the process. I mean, even with a will, your estate is going to take about 6 months to actually wind up and to be distributed. So if you don't have the will, you're probably adding another 6 months onto that. Plus you've got all the issues with maybe family challenging things because nothing's been written down, and folk are going to feel maybe a wee bit left out. In terms of the cost, you're probably looking at at least an extra, for a modest estate, an extra couple of £1,000 to get that done.
Okay. And how easy is it to actually set up a will?
Well, it is very easy. I mean, I've been doing this for quite a number of years, as you know, now, and I enjoy the business because when I go and see the clients, when I walk out the door, folk will almost invariably say, I'm pleased to say, that it was a lot easier than they thought, and they were glad they did it. Really, the interview, the will interview, if you do it face to face, probably about 30 minutes, 45 minutes to get all the details that you need. Right. And then it's just a case of going away, getting drafts approved, which isn't a difficult thing, and then getting the final version signed. So the actual will appointment should only be about 30, 45 minutes or thereabouts. It doesn't take a long time to actually do it.
And a question that we get asked, not all the time, but we do get asked it, and it's quite important, is can I disinherit children? And so a lot of people say, can I do this, can I do that? And the most common one that we probably get a lot of the time, and not understandably I suppose, but can I choose not to include children if I need to?
That's a really good question, and it's one of the things people need to be aware of. You can, within Scotland anyway, you can, to a lesser extent in England, but they've recently introduced laws in England, but in Scotland for years now, there have been things called legal rights. Mm-hmm. Now, legal rights mean that regardless of what you say in your will, legal rights mean that your spouse, if you're married or have a civil partner, and your children are entitled to a share of what's called your movable estate. Now, your movable estate is your investments, your bank accounts, things like that. It's not your house. So you can leave your house to anybody that you actually want. Bricks and mortar can be left to anybody, and it doesn't need to be your children or even if you own the house yourself, necessarily to your spouse. But any movable estate, your kids have the right to claim against that. So it's very difficult to disinherit in Scotland. The only way you can really do that, and I think we're going to go on to talk about them later on, is by putting your assets into trust. Yeah. And bear in mind as well, Bobby, and I know that you're very aware of this, but life assurance policies actually come into the movable estate. Mm-hmm. So it's really important that you do put life assurance policies into trust as you're writing them, because otherwise what you've set the life policy up for might not actually happen, might be to pay off the mortgage or whatever.
Of course. And it's also probably important to say as well that if you aren't going to leave your property to a spouse or a child, there's a potential for losing the additional residential nil rate bands of the £175,000 per person as well, isn't it? If it's jointly owned, it's an additional £350,000 per couple that they would lose out on should they decide not to leave it to direct descendants or spouses.
That's another really, really good point, and you need to be careful with that. And again, not many folk know about the residential nil rate ban, but basically what that means is that if you own your house, then you've got an extra inheritance tax allowance. Yeah. So if you own, depends on the value of the house, but you could have up to £1 million of inheritance tax allowance. But there are conditions around that, just as you've said, and it means that you need to leave your house to a direct descendant. So it needs to be a child, it could be an adopted child, certainly. Mm-hmm. Stepchildren are included in that as well. But yeah, you need to be careful what you're doing with that. And that's why it's really important to take good advice on it and to get the will sorted out, because these kind of things come out during the will process. So you can identify issues and problems that there might be. And when you think about the level of inheritance tax, it's high. Yeah. So if you make a mistake with that and you don't get your residential nil rate band, it could cost you, what, £120,000 or thereabouts.
Moving on to powers of attorney. So with powers of attorney, another kind of common one that we come across, and you've probably heard this yourself 1,000 times, I'm not old enough for a power of attorney. I'm not old enough, and I've got all my mental faculties about me, and realistically I don't need it. So I guess to dispel that, who should have a power of attorney, and why and when should they have a power of attorney?
Well, I would say, in a sweeping statement, I would say everybody should have a power of attorney. I have heard that, that I'm not old enough. I've heard even advisors having said to clients that, oh, you're not old enough to do this. Look, the time to do a power of attorney is when you don't need the power of attorney. Because see, when you need it, if you're lying in a hospital bed and you've got an oxygen mask in your face and what have you, it's too late to get one then. Yep. So do a power of attorney when you're young enough, when you're capable enough, when you've still got your faculties. If you don't have your faculties, you can't do a power of attorney. Yeah. And the alternative to a power of attorney is a very long, drawn out and very, very expensive process. I think we've learned a lot over the last year or so with COVID, and there's a lot of folk that have been hit and who have been taken into hospital that never saw themselves being in hospital. And these are folk that have really sort of seen the requirement for a power of attorney. I'm doing more and more powers of attorney now than ever. And I strongly advise all my clients, if they're doing a will, do a power of attorney. Doesn't matter what age, and if you've got your faculties, now's the time to do it. Don't wait until you've lost them.
I love that. The time to do it is when you don't need it. Really, it's all about planning, isn't it? Planning ahead, and that's what the whole wills, estate planning, power of attorney is. But to take it kind of back a step further, so just in case anybody doesn't actually know, what is it a power of attorney does, or what's the benefits of having a power of attorney?
Well, there are two aspects to a power of attorney, Bobby. Whether it's in Scotland, whether it's in England, it's a slightly different setup in England in terms of the paperwork, but basically the principles are the same. A power of attorney is split into two parts. You've got the financial side of things and you've got the welfare side of things. Now, the financial side of things is quite convenient, and if it's a married couple or civil partners, then it's really handy to have it in place, because how many of us have phoned Scottish Power or whatever, and they'll not talk to you because you're not the account holder. You know, the money comes out of your bank account, but you're not the account holder.
The ITV will not speak to my wife.
There you go. That's absolutely right. And it happens so often. So it's really convenient to have the power of attorney in place. It avoids that. And believe me, you get a great feeling of satisfaction when you say to somebody at the other end of a phone, look, I've got a power of attorney here, speak to me. You know, whether it's about the mobile phone or whatever it might be. So the financial side is really convenient. What I think is really more important is the welfare side of things. And that's when a power of attorney, you really see the value in it. Because, again, you look at folk who've been affected by COVID over the past wee while, but it's really distressing if a member of your family is taken ill. The medical profession can refuse to speak to you. I mean, should refuse to speak to you, because everybody's really sensitive about sharing information. If you get the power of attorney, then you have the right to speak to the medical profession on your family member's behalf, or whoever it might be, your friend's behalf, whoever you have that power of attorney with, or the power of attorney on. So the power of attorney is such a powerful document. And again, clients, just as we said a couple of minutes ago, yesterday I was seeing a client, almost every client I meet, and I don't need to sort of coin this as my own phrase, but you don't know what's around the corner. It's a favourite phrase of my clients. And that's why they'll do the power of attorney or arrange the will or whatever. But the power of attorney is so important, and don't wait until you're too old to do it. Don't wait until you don't have the capacity to do it. But that's how it works. It gives a lot of folk are worried about a power of attorney because they think they're going to sign away their rights to do anything. They're signing their lives away. That's not the case. The attorneys can only act when you're not really capable of acting, unless you give them the authority to do that. And you still have the right to control your own affairs. So while you've got your capacity, if you're lying in a hospital bed, you can tell the doctors what you want. But if you haven't got that capacity, then your close relative or friend or whoever it might be, they've got the ability to do that.
And you made a couple of points there. Is there any guidelines as who you should maybe have as your attorneys? Well,
if you are married in a civil partnership, then I would strongly recommend that your spouse or partner, civil partner, is an attorney. It depends. You need to make sure that, firstly, simple things like your attorney in Scotland needs to be over the age of 16. In England, it's over the age of 18. They need to not be bankrupt, and that's really quite important. But I think you choose someone who you know is going to take the responsibility seriously, and who's in tune with you, so they know what your wishes are. And it's always a good thing, even if you've got the piece of paper in place, it's always a good thing to have a chat. It's sometimes a wee bit difficult to have a chat if it's with your children or whatever, adult children.
Yep.
But tell them what your thoughts are, what you would really like. If you do end up, do you want to be resuscitated? That kind of thing. And that's actually one of the good things about doing proper estate planning. It does open up these conversations with your family as well. Yep. So just choose something that you're comfortable with. That's really, really important. And it's all about personal preference. And just make sure you tick the boxes in terms of their eligibility to be an attorney.
And how long does it take to set up a power of attorney, or what happens if it's urgent?
Right. That's a really good question. That's a moot point at the minute. Unfortunately, with COVID, there was a double whammy with that, and the Office of the Public Guardian, the people who register the powers of attorney, and they virtually shut their offices in the very early stages. So it meant that very few powers of attorney were actually being processed, and they're still working that backlog. You're probably looking about 3 months to get a power of attorney in place just now, and that's the normal course of events. So again, don't wait. You'll start just now.
Yeah.
If a situation turns out to be urgent, then we can process the powers of attorney, or ask the Office of the Public Guardian to process it, what they call expedite it. And the Office of the Public Guardian have been brilliant with that. If there's a genuinely urgent case, then they will pull out all the stops. For instance, Bobby, I had a case this week just where we requested the power of attorney to be expedited on Monday, and the registration was through by the Wednesday. So the Office of the Public Guardian, if it's an urgent case, they really are brilliant. And I genuinely can't speak highly enough about the Office of the Public Guardian. But in the normal course of events, it's about 3 months. So, like I say, don't wait until the last minute before you need it.
Moving on to gifts, trusts. So these are tools that can be used to really take advantage of estate planning itself for legacy and for inheritance, etc. So anybody that doesn't know what a trust is or what it's used for, Bill, if you're able to give us just a broad, they can be very complex, I understand that, and they can be, there's a variety of trusts themselves, but if you can just give us a rough understanding of what a trust would be and what it would do for a client.
Yeah, no problem at all, Bobby. Trusts are becoming more and more popular now, because again, we went back to the legal rights issue with children. What you're doing with a trust is you pass over ownership to your trustees. Now, you retain control of your assets. And again, that's really important to remember. You're not pushing away the control of your assets to somebody else. You retain control of the assets within the trust. And that's really, really important. And there are various reasons why you put a house into, usually it's a house, but investments can go into trust as well if they're in the right format. And you get all sorts of protection of your assets if you put it into a trust. And what that protection will be, well, firstly, we talked about what happens if you don't have a will. The trust is at kind of the opposite end of the spectrum of that. If you put your assets into a trust, then these assets don't need to go through the courts. So the assets can be distributed straight away. So as I said, a will can take 6 months to get the estate sorted out. If your assets are in a trust, if it's a house, for instance, the house can just go in the market and your beneficiaries can get the benefit of that as soon as the house is sold. The cheque just gets written over to them. There are other benefits as well. A lot of folk, and yesterday, again, I can speak from cases that I've had even this week, but yesterday I dealt with a lovely couple. We are going to transfer their house into trust. And one of the reasons that they were transferring the house into trust was they are a bit concerned about their daughter, one of their daughters, who is separated from her husband, but not divorced yet. And for whatever reason, the husband isn't keen to get the divorce through, maybe because he thinks he's going to inherit from the house of the in-laws.
Yeah.
And so they are transferring the house into trust to protect against that situation, because if a house is inherited through a trust, then your children are protected from losing their inheritance in a matrimonial situation, if they hit a financial situation, so if they were made redundant and even made bankrupt, then whatever they've inherited through the trust can't be touched by their ex-partner or by their creditors. So there's a big, big advantage to that. And also, again, quite common, if you have children who maybe have a disability, then if they inherit the house or whatever through the trust, then that inheritance isn't taken into account when the benefits are being assessed. So it means you can still get full benefits and still have the benefit of their inheritance. That's not touched, Bobby. And I think that's becoming, I'm seeing that very, very often. So these are all sorts of things that the trust can protect against. Plus, another important one is, there probably a couple more, but one I'll touch on briefly is that, folk, when one partner dies, because we're living longer, folk can remarry even into their 60s, 70s, 80s. Cool. And sometimes if the house is not protected in the trust but just left in the will, then the new partner can persuade the surviving spouse or partner to inherit or to will the house over to them. So if the house isn't in the trust, then the house can't be lost to a new partner who might then leave the house to his or her own children.
Yeah. And finally, the original parent children are missing out then, aren't they?
That's absolutely right. I mean, we talk about sort of, it's making sure that your inheritance is left through your bloodline.
Yeah.
And if you just leave things through a will, that isn't guaranteed that that's going to happen. So a trust would guarantee that.
Yeah.
And finally, if it's done under the right circumstances, a trust can protect the house against care. Now, you need to be really careful with that, but it needs to be done under the right circumstances. If you're going to go into a care home on next Monday, then a trust is not going to be effective for that. But if you've done it for all the right reasons and you're not doing it to deliberately deprive the local authority of an asset, then it can be protected against care costs as well. So that can be a really big side effect of the trust.
That's a really big one as well, like you said, Bill, because essentially if you've already paid your tax on your income to cover the costs of your mortgage, to then give the house away or lose it to inheritance tax, or for it to be taken out of the family to then cover care costs. So it is really all about the sitting down and planning. But you make a very good point about the trust issue of a property. So you can gift your house away, you can leave that within a trust, but obviously there are some kind of gift with reservation issues to consider there as well. Potentially you can't just give your house away and stay in it, for example, rent-free. You're not removing that from your estate. You're still going to have to pay inheritance tax on that. And not a lot of people are aware. They think, if I transfer this to my son or my daughter and stay here, then they own the house, and therefore it's no longer in my estate. That's not true, is it?
It's absolutely not. I collapse in a heap when I hear folk even thinking about transferring their house, especially to their son or their daughter. It's, in my view, and I can't hold back in this or be diplomatic about it, I think it's a terrible idea. Mm-hmm. It's an absolutely awful idea. And I've come across families who were advised to do that, but fortunately we spoke to them early enough. When you think about that, Bobby, if you transfer your house, especially if you don't pay rent, it is, as you know, without getting technical about it, but you're keeping some of the benefits, so therefore you're not actually transferring the asset over. But the other thing is, you imagine you transfer your house to your son or your daughter, who then ends up in a matrimonial situation.
Yeah.
All of a sudden, your house is part of a matrimonial dispute and a matrimonial settlement. Mm-hmm. So that son-in-law or daughter-in-law from hell, now hates you, you hate them, you're not getting on well with them. They own half your house. Mm-hmm. So it's just such an unwise thing to do. And there is, without going into the details of this as well, but there's a capital gains tax issue. So you really unleash a whole load of issues if you transfer your house to your son or your daughter or both. Just don't do it, is my advice.
Certainly speak to somebody anyway before doing it, so rather than just going and doing it yourself, then certainly speak to somebody to make sure that you're aware of all the issues that could potentially arise from it.
I think the message is take advice, Bobby.
Yeah.
I mean, I'm dealing with estate planning day in, day out. It's all I do. Eat, sleep, and drink that. So you build up, you've got expertise there, and you can see also you see the experience of your clients. So you see what good has happened, what bad has happened, and so you can advise on that.
Yeah.
And the good thing about if you're speaking to an advisor, especially about estate planning, we can be objective and in your own sphere as well, Bobby. That's the case. We're not part of the family, so diplomatically we can help solve situations and issues within a family, because you're able to take that objective viewpoint, and that I find is my clients find that really, really helpful.
Great, good. So to wind things up, Bill, again, we've touched on the trusts, and 7 years is the round golden number in inheritance planning, isn't it? So if I have a trust or I put something into trust, do I need to live for the 7 years in order for me to benefit from the trust itself?
That's a common misconception. The answer to that is basically no. If you put the assets into a trust, then the assets are protected straight away. You don't need to worry about the 7 years. The 7 years, though, as you know, it depends. If you're using trust for inheritance tax planning, then it could be the case, because it's still within your estate within that 7 years. But in general terms, with the most commonly used trust, and if it's to protect against the things we've talked about, the matrimonial and all these things, the executive costs, then the 7 years just doesn't come into it. So there's no issue of assets needing to be in the trust for 7 years.
But for inheritance tax purposes, it is.
That's different. That is different. And that's where you'll hear the 7 years, and that's why folks think, going back to what you're talking about transferring the house to sons and daughters, they think, oh, if they have it for 7 years, then I'm protected against care and all these kind of things. And that's just nonsense.
No.
And if you're trying to transfer your house to protect against care to your son or your daughter, take my word for it, the local authority can go back as far as they want. So it could have been 20 years ago, and they can still say, look, get the house back into your name and then snaffle it. So, it's the 7 years. Be careful with it.
Brilliant. Well, we've covered quite a lot there. And again, I'd just like to thank you for your time. I know that you're a busy man. And I'm hoping that we've really kind of shone the light on some of the kind of basic issues of why people should sit down and look at these things. And I think you've hit the nail on the head. That there is no right time, there is only right now, essentially. And to do these things, a lot of people think that it's morbid or they're tempting fate. Essentially, the underlying truth is that by not doing it, it's actually going to cause an awful lot more time, hassle, costs, and emotional kind of pressure at a time that you're really probably going to want to avoid that, because the family are in a very vulnerable time when they've lost somebody, or their mental capacity goes, or the family really feel that. So I think you've hit the nail on the head with regards to the reasons to do it. So thank you very much for your time, as always. Brilliant knowledge, Bill. Really, really enjoyed that. Thank you very much, and I'll catch you soon.
It's a pleasure, Bobby. Good to speak to you.